Judgment in the matter of Lifestyle Equities and another against Amazon UK Services Limited and others.
This case is about the development of the law of trademarks in response to the marketing and sale of goods across national borders on the internet. Traditionally, the registration of a trademark only protects its owner from its unauthorized use in the course of trade in the territory in which the trademark is registered. So, if a consumer from the UK goes to New York and buys goods bearing the UK registered mark and returns to the UK with the goods in their luggage, there would be no infringement. The seller would not be using the trademark in the UK, and the buyer would not be importing the goods into the UK in the course of any trade. But the marketing and sale of consumer goods on the internet knows no such territorial boundaries. The seller can advertise and sell goods made abroad on a website based abroad in such a way as to come to the attention of a UK consumer. The UK consumer never need leave their armchair at home to view, choose, and buy the goods, which are then delivered to the consumer's home after the sale has taken place. And the seller can use terms and conditions of sale which provide for the sale to take place abroad and for the import of the goods to the UK to be undertaken by a separate firm acting as the consumer's agent. The seller says that it has done nothing with the trademark in the UK and that it did not import the goods bearing the mark into the UK. And if that is right, then the law of trademarks is rendered useless in connection with cross-border internet sales. But the European Union, which included the UK at the relevant time, developed two new legal principles to deal with that problem in relation to trademarks registered in the EU. The first is to treat the advertisement and offer for sale of trademarked goods on a foreign website as taking place in the EU consumer's territory if consumers there would think that those advertisements and offers were directed and targeted at them. The second is to treat a sale of marked goods as a use of the mark within the territory if the sale is made to a consumer in that territory, even if the sale transaction takes place outside it and there was no targeting of that consumer. It is the first of those principles, which I will call targeting, which is the main subject of this appeal. The alleged infringement of the respondents' marks all occurred before the UK left the EU, and the proceedings began before the end of the Brexit implementation period, so that the EU-wide system of trademark law was applicable at the time, even to goods targeted at the UK. Since the effective date of the UK's departure from the EU, the former EU-wide marks have been replaced by UK equivalent marks, but the law about targeting remains the same as it was before Brexit, so that the decision on this appeal is of much more than purely academic or historical interest. The appellants, which I will call Amazon, are companies within the well-known Amazon Group, headquartered in the USA, but with a well-established business of marketing and selling consumer goods internationally using the internet. They were sued by the respondents, companies in the Lifestyle group of companies, for infringing a set of their EU-registered trademarks by displaying them on consumer goods, mainly clothing, sold on Amazon's USA website. Amazon denied that the goods bearing Lifestyle's marks or any other goods were advertised on the Amazon USA website in a way that targeted them at consumers in the UK, or for that matter, anywhere else in the EU. Rather, they said the goods displayed and sold on the USA website were targeted at consumers in the USA, while Amazon used locally based websites to target goods at consumers in the EU, for example, a UK-based website to target consumers in the UK, and a German-based website for German consumers, and so on, where Lifestyle's trademarks were not, or would not in the future, be used. The trial judge, Mr. Justice Green, accepted Amazon's case. He thought that goods displayed on the Amazon USA website were not targeted at the UK or at any other EU member state, since, first, UK visitors to the USA website were directed to the UK website. Secondly, the use of the UK website would typically produce lower prices and faster delivery times for the UK consumer. Thirdly, there were statistically few sales of the relevant goods to the UK. And fourthly, because he regarded lifestyle as pursuing these proceedings with an ulterior motive, rather than simply seeking to prevent targeted sales. The Court of Appeal, Sir Geoffrey Voss, Master of the Rolls, and Lord Justices Arnold and Snowdon vigorously disagreed. In their view, the Amazon USA website clearly targeted the relevant goods at UK consumers. They relied in particular upon the, quote, review your order, quotes off page, where the offer for sale is made to a named consumer with a UK address, with UK-specific delivery times and prices, and the option is given for the consumer to pay in sterling with the exchange rate provided. This court unanimously dismisses Amazon's appeal. Lord Kitchen and I give the leading judgment jointly, with which Lords Hodge, Hamblin and Burrows agree. Our reasons may be summarised as follows. The task of the court in assessing an allegation of infringement by targeting consumers in a protected territory from abroad is to look at the evidence from the perspective of the average consumer, that is, someone reasonably well informed and reasonably observant. The mere accessibility of an overseas website to the UK consumer is not enough on its own. The question is whether the average UK consumer accessing the relevant overseas website would think that the advertisement of the marked goods was targeted at them. The court has to look at all the relevant circumstances and reach a balanced conclusion where there are pointers for and against targeting. For that purpose, this court conducted a detailed and careful journey through the successive pages of Amazon's USA website, from the landing page to the point where the average consumer would complete their order for the relevant chosen goods. In our judgment, looking at that journey as a whole, the pointers which would lead UK consumers to think that the USA website was targeting products, including the relevant branded products, at them, greatly outweighed those pointing in the other direction. The USA website is programmed to detect where an incoming hit is coming from, in this case from consumers with an IP address in the UK. Then it automatically adjusts the areas of its pages so as to include the label, quotes, deliver to the United Kingdom, quotes off, to invite the consumer to view products displaying sterling prices, and to view products available for delivery to the UK. On each product page, a message under each product for sale tells the consumer whether it is or is not available for shipment to the UK. And as the Court of Appeal noted, the final Review Your Order page is all about a sale to a UK customer, with delivery promised to a UK address, with specific UK delivery times and the option to pay in sterling. There were some contrary indicators, such as an option to use the UK website and the display of US dollar prices if the sterling option is not selected. And as the judge said, some UK website prices and delivery times were more favourable than those for delivery to the UK on the USA website. But this would not easily be apparent to the average consumer, and not in relation to the relevant branded products if, as Amazon implied that it planned not to do, it did not display them for sale on its UK website. And unlike the judge, we did not consider that Lifestyle's motive for bringing these proceedings was relevant to the targeting question. This court does not approach a multifactorial balanced evaluation such as this one on the basis that it should simply substitute its decision for that of the lower courts merely because it disagrees with them, where the opposite conclusion is reasonably available on the facts. It is necessary for an appellant to show that the lower court has made an error of law or principle, or that there is some flaw in the lower court's treatment of the evaluation, such as a gap in logic, a lack of consistency, or a failure to take into account some material factor which undermines the cogency of the decision. The joint judgment gives detailed reasons for this court having reached that conclusion about the evaluation conducted by the trial judge, and why we felt it appropriate to carry out our own detailed evaluation of the targeting question, rather than just accept that undertaken by the Court of Appeal, even though we did not in the end disagree with the outcome in that court. Our decision that Amazon did target UK consumers with its presentation of the relevant branded items on its USA website is sufficient to require the dismissal of Amazon's appeal. But the Court of Appeal also found against Amazon on the second EU principle, namely that the branded goods were also sold to consumers in the UK. This finding depended upon its interpretation of a single decision of the Court of Justice at the EU, in a case called Blomqvist and Rolex, in which there was no targeting of the counterfeit goods. But we did not consider that the report of that case provided a sufficiently detailed description of the underlying facts for this court to be able to form a reliable view about whether it laid down a legal principle which applied to this very different case, where, in any event, targeting has been established. Accordingly, we say nothing about it, or the Court of Appeal's interpretation of it, in our decision.